Hi, Harishchander Anandaram sir. Welcome to Joel
Hi,
Janje.
sir.
Welcome to Joel Janje YouTube
Thank you.
channel. And in
It's a
this
pleasure.
video, okay, sir. In this video, sir is going to speak about intellectual property rights. So it will be a lot of an eye-opening section for a lot of authors, researchers, and people who want to know about research, and it will help you to understand what to share and what not to share. So this is a very useful video for social media activists as well, because even in social media we are not allowed to share others content. Okay, and Sir is also interested on giving you free ebooks. So, and also those who wants to resolve your queries which are regarding biotechnology or bioengineering or the upcoming fields in biology field, you can send a message to sir's WhatsApp number. So sir, when he is free, he will revert back to you. And also if he can give a ebook or some material on that topic, he will be helping you out on that as well. So I will give sir's number on the WhatsApp number in the description of this video. And telemarketers, please don't spam and disturb sir, because telemarketing calls only after getting the approval you can make. That's a rule as well. So please avoid that and for use it for your learning and beneficial purpose. Okay, sir. Thank you very much for the ebook offer for my viewers. Maybe the first giveaway from Joel John J YouTube channel is being given by you. And thanks a lot on behalf of me and my
Sure,
channel
sir.
and also viewers. Okay, sir. Please go ahead.
Thank you. And thanks for the introduction. And today we'll be discussing about the intellectual property rights. And the objective of the webinar is to know about the opportunities regarding the intellectual property rights and the vital aspects intellectual property rights as well as the patent play in academics and industry, and to understand the relative procedures for protecting different intellectual properties. Most people think it's only the patent and copyright. There are a lot of intellectual property rights like trademark and etc. Even the geographic index. It will be discussed in detail. So the main aspect is to clarify the basic doubts, misunderstanding, and uncertainties about the intellectual property and the intellectual property rights. So most of the intellectual property rights for academicians as well as industries are designed by the company secretaries, and then the government of India approves it. If a company secretary or a corporate secretary working as a consultant, these are the following activities they need to make. They can patent if it is a product or a process worthy aspect. They can have a trademark if it is their company based manufacturing. As you can see, Coca-Cola will have its own trademark and design also. You can see the Shire and Plywoods, no? They have their own design. As well as the copyright. Whatever books we write, no, that becomes a copyright of the publisher, and the revenue will be shared to the author also. And then geographic indications. Famous geographic indications are Tirunelveli Alva, for example, Srivilliputturu Palgo. All these are geographic indications. Even Kanchipuram silk and relative aspects. So, company secretary can prepare applications for the registration design, copyright or GI based on the clients. Now, government has taken initiatives in most of the universities and colleges. Atal centers were set up by the government. So they are taking care of the intellectual property rights. So every university is maintaining a separate patent office nowadays. They to take care of these things, because for an individual faculty alone it's a tough job. So they are merging admin part of the university to help the faculty in extending the process. And they also need to mention the registration number. While filing an intellectual property, you need to understand the difference between the filed design as well as the final grant. Initially, you file a patent application, get a number that is filing, and you make a relatively novel design that goes in the design aspect. And finally, the patent which is getting granted can only be transferred. The filed patent or a design patent cannot be transferred, only the grant patent can be transferred. The next opportunity is the company secretary who are involved or the patent office, no need to worry about it, because they don't have the power of attorney to sign. They can only suggest. The sign will be taken by the chief investigator or a relative administrator who is involved in the project. So many people will have the myth, suppose if I submit it to the company secretary or a patent office, any problem, nothing like that. They don't have the authority also. It is better to do it in online, because in offline, any paper you submit anywhere, there is a chance for the paper to go to a relatively different table than the actual table. But when you do it in online, when you have the proof for online, no need to worry about any malpractices, because it cannot happen. Once they have found any relative malpractices, it's a very big threat for them. Than us, it's a very big threat for the person who's the head of the patent office or secretary of a company. So the terms intellectual property, a property created by persons only, because there were certain myths where you can see, like US government has taken patent for turmeric. Nothing of that sort can happen, because turmeric is a natural product. Neither US nor India can of it. But the molecule curcumin, because that is a derivative. They have worked on it to extract the molecule, and they have reworked on it to make it into a medicine. That obviously, because they did it first, they should be given the patent. If we do it first, we can be given the patent. Even the relative molecules of curcumin are being patented in India also, a different form and a different version. A professor in CLRI also owns many patents for curcumin related products. So, intellectual property can be a word, that is a copyright, a symbol, that's a relative design, a logo, that's also a relative design. So the intellectual property granted by the government can be transferred commercially by disclosing the IP as well as the IPR relative application. There are around 20 to 25 rules for having the IP and IPR related application. Most of the people working in institute or company, even industry, know only the partial part of it. So it is better to have a lawyer-based consultant to finalize all those rules and transfer the agreement. Similar to when we buy or sell a property, it's better to consult with a lawyer and do it. The same thing we need to follow here.
Yes, sir. And you said that
So the
in CLRA also one scientist has got a lot of patent. Is it Central Leather Research Institute
yes, yes,
at
yes,
Chennai? Okay,
yes,
sir. So
yes,
what
yes.
they do with turmeric? Sorry for getting deviated, but I'm much interested on knowing a little bit about that. Can you give a little bit?
Actually, sir, the CSIR has set up many research labs in India. That is Council for Scientific and Industrial Research. In CLRI, initially it was only a leather-based research, tanning process and relative patents they got. Then one department came ahead to work on the medicinal related products, so that the leather tanning process also, the molecule they have developed should be useful, as well as a part of it can be given as medicine also. In that case, the molecule which derived from turmeric, no, curcumin by US is once again reworked, and they have started resynthesizing. There were some molecules which is showing different properties, but with the same level of absorption. So they have finally analyzed it's the beta variant, not the one they have analyzed. So they have documented it clearly and they got it patent. And even this molecule is also being patented. And even one of my friend who works on the relative model is having a white curcumin, a relative other variant. He's trying, he has also got patented, and he'll be commercializing it soon. But the thing is that the rate of synthesis cost is very high. So he's working with organic chemists to reduce the cost and going ahead for it.
Okay, sir. Thank you very much for the insight. And this is the first time I hear that Central Leather Research Institute in Chennai. It's in Adayar's area, right? So I always used
Yes,
to,
yes.
whenever I go near that area, as my church is there, I used to admire at this
Mm.
great institution, Anna University, IIT, and CLRA. And very happy to know that the Leather Institute also is getting into medical related work, so that what is being found out in one place can also be used for other benefits, and also due to this patent right and working on cost and others, the whole entire human race can get benefited out of it. Okay, so please go ahead with your presentation.
Definitely, sir. Thanks a lot. So as we know, it's an asset. So owner as well as the commercial relative partners are involved. And the IP owner can stop other manufacturing units by selling the products if the right is not being given. And IP owner can sell the licensing also to the relative products for commercial gains. So the importance of IPR involves establishing goodwill and a brand value in the market. The inventors, creators, as well as the authors of the intellectual property should agree upon acceptance. Even if anyone hesitates, that acceptance cannot go to the next level. And then the IPR certificate establish a legal and valid ownership of the intellectual property. And one more doubt many people have. Suppose if you want to sell a product you developed in India, you should get an Indian patent only. If you want to sell it in US or UK, you can get the relative patent. There is a patent, global patent they call, where you can sell all over the world, but that is the costliest patent. It's very tough for individual commodities to do it. Only people who got global patent, namely, is one is Byju's. He invested a lot in global patent. At the end of the day, he's struggling now. And Tata Groups, they have global patent for their products. Similarly, Reliance and relative groups, they have. Khan Academy, they were the first to introduce online based examinations. That was patent since they developed a small product out of it. In a chip, you need to attach the chip. Generally, the online server will get connected during those days. They were successful in the US, and then only Byju's and other people came.
Okay, sir. Happy to know that a lot of industries are also involved in this. Please go ahead.
Definitely, sir, because without patent and transfer, it's tough for a global market. So when it comes to the kinds of IPRs, as I have told already, IPRs can be safeguarded and monopolized also. And there are various acts of IPR. Here only the lawyer's value come into existence. The Patent Act 1970, which indicates the relative intellectual property, and then the Design Act. Many people stated that it takes minimum 1 to 2 years to get the final product patent. So the design which we modify also should be given like that, and also that gave rise to the Design Act. And then the Trademark Act, because many companies told they require a trademark symbol for their model. So that act came. And then the geographic indications. Many people claimed that because nature itself has given us a lot of things, it's not everything we take care. So since for a patent, an individual work has to be involved to a greater extent, they named it as geographic indications. Because Kanchipuram silk, we are not doing anything. It's nature which is giving us. And then the Copyright Act. Many people in olden days, they used to write in papers or in some leaves and other thing. But those also contained relatively good information. How to protect it is from the based on the copyright, digitalization and relative aspects. And the integration circuits, layouts and design. Because electronics people, they wanted a separate unit to monitor them. So they had it. And Plant Varieties and Farmer Rights Act in 2001. And also the Trade Secret Act. So all these relative acts were in intellectual property. And I can tell you an overview, but only the lawyer knows the depth of it, and he can only suggest you which specific act to go ahead and file it.
Okay, sir. Happy to know about that. So there are these many types of acts are there, so which we can prevent about that. So that itself, it's a very big eye opener for a common man who thinks that most of them don't even know about the Intellectual Property Act. They just know that patent right and all those things, and trademark is also is now getting little bit more known. So you have got something more to share about that, and the geographical indication is something little bit confusing for me. So if you can give me some more thing like who can get benefited out of this geographical indexing indication act, it will be more insightful.
Sir,
Please go, sir.
a country will be benefited, sir, rather than an
Okay, sir.
individual. If a country has more geographic indications, then the country is more wealthy because economics has to be redefined in this case. Even our former economics minister Chidambaram, as well as Subramania Swamy and Manmohan Singh sir used to say, it's not only money. You cannot measure economy based on money alone. It is the wealth and natural heritage which has to be maintained. In India, we have around more than 35 GI tags at present.
Oh, great.
But in US, there are around only 6 or 7 GI tags.
So we are leading.
In countries like Africa, where we are naming it as poor and not treating them properly, not all, but most of them, but they have more than 45 GI tags.
Oh, they are leading us.
The wealth of Africa is something which has not been explored, or the people who explored are not transferring it properly.
Okay. So
So
that's why people
the
are
term
suffering.
poor, yeah, the term poor is the indication of poor management.
Poor management and also the problems in the trade practice and fair trade practice mainly. Whether the wealth is getting shared on a proper way. Okay, sir. So please go ahead with the slides and further
Sure,
information.
definitely. Definitely. So, UNESCO will rank the country as a rich country based on the geographic indices only.
Okay, sir. Happy to know about that. So please go ahead with the
And
other
most
things, sir.
of the heritage sites given by UNESCO are in India and Africa.
Oh, so we are also much benefited by this.
Yes.
Okay, sir. So please go ahead with the other things like patent trademarks.
Sure, sure, sure. Sure. So, the trademark indicates words, signs, logos, and the design to protect ornamental configuration. Most of the people who design ornaments have their own design based intellectual property, because how people identify whether it's from Lalita jewelry or NESE based on the design.
I think they would be having a small initial kind of thing
Yes,
on the
yes,
jewelry.
yes, that is a design registered, right? Or else it's tough to discriminate.
Yeah, very tough because I used to wonder about looking at this jewelry and other things, how this design varies because those things will be very minute thing, but the shine and everything,
Very
the
minute.
yeah, very minute and the shine difference and everything that jewelry shows is really a great thing. I wonder how these designers are able to think before they design. So they also should definitely have the rights for their hard work.
Of course. Geographical indications and the copyright. Copyright not only to documents or essays, even the artistic work like poem and the public speech, they can also be coming under copyright. That's why mostly when you have a conferences, you can see the logo down, no copyright this conference. In many conferences, you can see that.
Okay, so and also my next plan is write a poem book. So a very useful message for
Okay.
me.
Mm. You're planning to publish by yourself or planning to publish through?
So how I follow the safe practices? First, I will publish it on Amazon ISBN and get an ASN number,
Okay, okay,
and also look for
okay,
how
okay.
far the ebook performs. Then what I will do is then I will
True,
go
true.
ahead with the publisher. And one thing which I found so great about is the book price you are going to charge, because when we go for a publisher, mainly that Amazon price, they charge much higher than any other publisher, as I know. So even if you
Yeah,
publish with Amazon, the ebook will be moving through, but the printed book price has they do will have a very different set of quality standards and others. But commercially, mainly in India or even in US, the competitors who publish it with some other publishers who can make the product at a very lesser price will have the sales market. So
definitely.
what I do is I will first go with the ebook, then only I will move with the publisher. As far as India, I have moved with the cover fox so that I can sell it on India as well. And I think in India we need a publisher to sell our books. We cannot do self-publishing for printed books. Ebooks are allowed, and that's also another one reason. So happy to know about that. Musa. Okay, so fine. So we can go to
Sure.
the presentation.
Yeah. So, patent is a monopoly right granted to an applicant by the government, any government in that case, to practice the term invention. And after invention, you need to manufacture and scale it. There comes the corporate people. Because if an individual can manufacture by himself, no need for a corporate to come in. But every individual cannot start his own factory and manufacturing units, and he requires the help of a corporate. And the patent confers rights to the patentee to exploit the patent for commercial gains because the transfer can be given and stop other manufacturing units or process. That is possible. So the invention is related to a product, that is a machine, for example, and then a process also is there. So according to the Patent Act Section 2, what they say is a new product or a process. Inventive step and the capacity of industrial scalability. Because you might patent something which is slightly different from the existing one, but will it have scalability in industry? That is the major question. So the product, that is the device, machine, composition, and the process for getting a tangible product that is patentable. Only if the product or process is novel, which involves an inventory step that is non-obvious and which has the industrial application, then only your patent will be filed. And then the procedure for a grant patent. Initially, filing is required. Publication of the patent application will take 18 months, and filing a request for examination. And the pre-grant opposition can be given if a person is interested to give an opposition. And the examination of the patent application will be based on the examiner's request. And then we need to give a reply to the requirements and the objectives raised in the patent office. And we need to attend the hearings multiple times if it is required. Acceptance or rejection of the patent application is up to the committee. And the publication of grant patent application from the basic publication of the initial filed application will be done in a year time. And even after getting the grant, the post-grant opposition is possible. And then you finally get the grant. So the documents required for filing a patent is the application form, specification of the process or product, the drawings, if needed to clearly explain the sufficiency of the patent, and then the undertakings taken under Section 8, Form 3, and the declaration of inventorship, Form 5, the complete specification filed after the provisional patent, and then the document to claim priority in case of the conventional application, and power of authority if the patent application is filed through a patent attorney. The term attorney is also a lawyer's term. And then the patent specification can have two types. One is the provisional specification. Companies mainly do the provisional one, the description about the invention and the relative process. And the complete specification involves a description as well as the claim. So the description gives the best mode of a detail for practicing the invention. And it enables the skilled people to work without much experimentation. And the claims given in the legal section will have the key for all patents to protect legal rights. And then the boundaries and the determination and the sale authority needs to be discussed with the financial sector officer if it is going through a corporate, and then gains it. And who can apply for a patent? Anyone can apply for a patent. There is no restriction and all. But the first inventor holds the right of ownership. Because I share my patent with 10 people, it doesn't mean that everyone is an owner over there. A person who is a legal representative of the first and true inventor will have the assigning authority, and the legal heir of first and true inventors, in case of demish of the true and first inventor, can give the rights to the second authority. And all these legal terms are given only in general. There are a lot of subsections in transferring of power, authority, and other things. Only the financial sector manager as well as the lawyer can explain in detail. So to continue a patent, where to file an application, you have a patent office in Delhi for the states of Haryana, Himachal, Jammu, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, and Delhi and Union Territory of Chandigarh. It's only the Delhi office. So no other go. All the subsidiaries can have a sub office in that place, but the main thing will be signed in Delhi only. And then in case of Mumbai, the states of Gujarat, Maharashtra, Goa, Madhya Pradesh, Chhattisgarh, Diu, Daman, their union territories, and Haveli will have their main office. And in Chennai, the states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and union territories of Pondicherry and Lakshadweep. In Kolkata office, rest of India. So Kolkata office will have a tough time in reviewing most of the applications from Bihar, Odisha, West Bengal, Sikkim, Assam, Meghalaya, Manipur, Tripura, Nagaland, Arunachal, and Union Territories of Andaman and Nicobar. Tough job.
And Chennai office, the Intellectual Property Act office, the one nearby the Gindi Industrial Estate, right, sir?
Yes,
From
yes,
Mount Road, we
yes,
have to
Nungambakam.
Tani, yeah.
Yes, yes.
Nungambakam or the nearby the Saidapet. I will be used to tanning to a nearby the Gindi Industrial Estate bus stop. We have one Intellectual Property Act office.
Um,
Is that the one or?
Actually, sir, that is for small scale industries, sir.
Okay, sir.
Project and other thing. In Nungambakam only, in Sterling Road, we have the
Oh, in Nungambakam, Sterling Road, we have another one. I never know that. I
most
used
of
to.
the government offices are in Nungambakam Sterling Road only.
Oh, great to know about that because I used to always go to that Sterling Road. Earlier, I worked in an office on Harrington Road on HP Towers.
Okay.
So I always used to go by that way, but I never know that this office is there. As I stay in Saidapet, sometime when I roam around and want to turn inside Mount from Mount Road, this Intellectual Property Act office will be on my site. I'll be entering into the Gindi Industrial Estate area through that place.
Yeah,
Okay, sir.
because for small scale industries, they have a separate layer.
Great to know about
Because
that, sir.
small scale industries, you don't need to go through all these process.
Okay,
Some
sir.
slight modification of the existing thing, because they don't require larger scalability, no.
Oh, yes, sir. Very true. And also, the Sterling Road office, Sterling Road is also much known for all the people because in Nungamakam and the Checkpet, it's on the connecting place.
Because all income tax office, AGS audit, and all those government big offices are in that Nungambakam area only.
Okay, sir. Fine, sir. Okay, sir. Please go ahead.
And then the life of a patent is 20 years from the date of patent, max. And the government fee for filing a patent application for an individual, it's only 1,600. For small scale industries, it's 4,000. Private and public companies, 8,000. So the opposition of a patent is under Section 25 of the Patent Act, that is wrongly obtained invention, publication before the date of patent. This is the key point which I have addressed already. Prior claiming, that is claiming before the discovery, and invention known to everyone, and without an inventory step, just doing a mild variation in the process. So all these aspects will not come as an invention as per the Patent Act. So the opposition
Sir, we have
to a
only 10.
patent,
Sir, we have only
no,
10 more minutes. So can we close it within that or will it take more time so that we can go with
no,
that?
no, no. We'll try to do it a little fast. So the opposition involves invention not described clearly and sufficiently. And then the undertaking under Section 8 about filing a patent abroad also after getting it is not proper, or else the convention application not filed within 12 months, and no disclosure about the geographical origin. All these factors also will have a negative role on getting the patent moving to the next step. And anticipation and traditional knowledge. All traditional knowledge and anticipation cannot be patented. And revocation of a patent can be revoked at any time on any grounds, subjected to opposition. And the application for revocation has to be given to the Intellectual Property Appellate Board to establish a government investigation to work on the patent filing based on the Amendment Act. Even this is possible. And PCT is the Patent Cooperation Treaty, an international treaty which provides facility for the applicant to make a patent, a global patent based on the invention. And this international phase of patent application is under PCT Act. And PCT applications are filed at any nation receiving the patent authority, and all these acts are covered by WIPO Geneva. Only Geneva has the right to tell PCT to grant or not. And WIPO is only a subsidy unit. The applicant can claim the date of filing as per the priority date during the national phase entry. So while doing itself, you can do the international thing also. But provided that someone should not be already working over there in this similar area. So what are all not patentable is well-established natural laws like perturbation, motion, gravitational force, you cannot. And an invention contrary to public health or morality or toxic drugs, food items, drinks, you cannot. Mere discovery of scientific principle or formulation or a non-living substance occurring in nature, you cannot. And then the mere discovery of a new property, you cannot. And the substance increased the efficacy in a machine, that also you cannot. And the substance obtained by mere mixing of two relative properties to get a product, not possible. And mere arrangement or rearrangement of known devices to work differently, that's also not possible. And then the method for agriculture or horticulture, not possible. It's a natural process. And a method for treating human beings and animals without intellectual act, not possible. Plants and animals in a whole or thereof microorganisms, not at all possible. Natural occurrence. Mathematical or business method or computer programs, algorithms, not possible. Literature related works, drama, music, artistic works, not possible. And then a mere scheme or a rule for performing a game, not possible. A presentation of a basic information, not possible. Even integrated circuit relative topology modification or topography modification, not possible. Invention related to traditional knowledge, not possible. Related to atomic energy, only in section 4 you can get the detailed aspects of it, and mere invention is not possible. So you can have your questions related to patent.
So anyone who is having a question and answer, please type it on the comment box so that so I will be in future sections. I will check with sir and answer it. Press the thumbs up icon. Press the share icon and share it with your friends, and also save it to watch later. And also we are coming up with lots more videos. So thank you very much for your time, and sir, and thank you very much for the viewers. It's time to say bye.
Definitely. The geographic index alone, we'll have a separate video, sir.
Okay, sir, sure,
GA
sir.
tags.
Okay, sir, thank you very much for that. We'll have a separate video for the geometric index as well. Okay, sir. Bye, and bye for the viewers. Bye.
Bye-bye. Thank you.